Welcome back, Rich, and welcome to Risk Management Live. Today's topic is going to be the Supreme Court's gay marriage ruling, impact on pastors and churches. There were two recent rulings that happened last month, so we figured we better tackle them again. But before we get to that, I want to let you know that your questions and comments can be submitted to us by email at riskmanagement@agfinancial.org. You can actually go to the bottom page if you're watching this live right now and actually submit your questions. I get them right here as we're talking in the comment section, or you can do it by tweeting us. If you use Twitter, please direct it to @agfinancial or use the hashtag riskmanagementlive. Rich, the two court findings, which I was really kind of surprised that the Supreme Court came back so quickly, number one. And of course, there was a 5-4 split decision on both of these topics. But let's first talk about the Defense of Marriage Act and how the Supreme Court's ruling ruled on the Defense of Marriage Act.
Okay, Jerry, and let me begin by saying that the Supreme Court did issue these two rulings last month pertaining to same-sex marriage. And we're going to talk about both of these rulings and their impact on churches. But I'll just say this. I've received a lot of calls since these rulings, and there's a lot of concern, apprehension, anxiety even on the part of many church leaders regarding the impact of these rulings. There's a lot of people, Jerry, that feel that because of these rulings, pastors may be prosecuted or may be sued for civil damages for refusing to perform a same-sex marriage contrary to their religious beliefs, and churches may be subject to some liability if they don't permit these marriages to be performed on their premises. Those are the two pressure points. I think those are the two most common concerns that I hear, and I've had a lot of church leaders call me about these. So today, this was not our intended topic for today, but we decided to cover this to try to relieve some of the anxiety out there by explaining what these rulings said and what their implications in fact are. So let's begin by looking at the DOMA case. And of course, DOMA stands for the Defense of Marriage Act, which was a 1996 federal law that Congress enacted by overwhelming bipartisan majorities of about 85%, signed into law by President Clinton. And Section 3 of this statute define marriage for purposes of federal laws and regulations as a union between a man and woman. So for federal purposes, not state, but for federal, marriage only, whenever you see the term marriage in a federal statute, it only pertained to marriages between a man and woman. And you say, well, what's the significance of that? Well, it turns out, according to one count, there are 1,136 provisions in federal law that use the term marriage or spouse. And so it's very critical how this is defined. And so for DOMA to say that it only pertains to opposite sex or heterosexual marriage had a significant adverse impact on same-sex marriage. So the Supreme Court in the DOMA case basically said that provision defining marriage solely as a union between a man and woman was unconstitutional for two reasons. Number one, it invaded the province of state and local governments historically to make decisions regarding marriage and domestic relations in general. Here we have the federal Congress defining marriage, and that has historically been a state or local function in this country. And secondly, the court said that that this section of DOMA defining marriage between a union between a man and woman violated the Fifth Amendment, or not the Fifth Amendment, but Article 5 of the United States Constitution, which incorporates the concept of equal protection. It only refers to due process, but the Supreme Court has interpreted that phrase to embrace and to encompass equal protection of the laws. And so the idea is this. Here in one of the 13 states and the District of Columbia that have recognized same-sex marriages as being lawful, you have some people being recognized as married under federal law and some people that are not under DOMA. Because under DOMA, even if you're in one of the 13 states where same-sex marriages are permitted for state purposes, they're not permitted for federal purposes. And so you had this dichotomy. You have this two classes of people. You have approved marriages, disapproved marriages. And the court concluded that violates the equal protection concept embedded in the due process clause of Article 5 of the United States Constitution. Now, it's very important to point out here that the court had the opportunity but refused to take it to come up with a sweeping ruling that same-sex marriage is a constitutional right, period. They didn't do that. It was a very measured, it was a very limited ruling that said that same-sex marriage in the states where it's valid, where it's lawful, 13 states plus DC, in those states, DOMA is unconstitutional because it would create a two-tier marriage situation with some marriages being recognized under federal law, some marriages not. So obviously, we've got 37 states that by statute or constitutional amendment define marriage as a union between a man and woman solely, no same-sex marriage. So in those states, DOMA still applies. So as you can see, we have emerging this kind of disparate treatment based on where you live, and that's why a lot of commentators, legal commentators and analysts believe that the Supreme Court inevitably is going to have to weigh in again on this topic. I'm not so sure that that's going to happen because there have been members of the Supreme Court, including some of its most liberal members in recent months, who have intimated that maybe they got the abortion ruling wrong back in 1973, Roe v. Wade, by appropriating that decision for the country and taking it away from the electorate. So you have 6 out of 9 judges say abortion is a constitutional right. And that's why we have had 40 years of turmoil in this country. And that will continue forever because the electorate, the people, were deprived of the right to make this decision. In most European countries, the abortion decision was made through the electoral process, and they haven't had the chaos and the anarchy that we've had here over that ruling. And so the idea is maybe when it comes to same-sex marriage, another controversial issue, maybe we should leave this up to the states to decide. So we may be surprised at how the Supreme Court ultimately would rule on that case, but it certainly is possible and perhaps even foreseeable that the Supreme Court would recognize a robust constitutional right of same-sex marriages. And if that does in fact happen in the future, I think it's important to point out that those 37 state laws and constitutions that define marriage solely as a union between a man and woman, they're going to be swept away by that singular ruling, probably in a 5-4 decision of the United States Supreme Court. So we'll just have to wait and see. And so, Jerry, you might say, well, what's the relevance of this? What are all these federal law provisions that pertain to spouses and to marriage? Let me mention some. Number one would be Social Security benefits. Under the Social Security program, benefits are made available to surviving spouses and to spouses in general, even if the other spouse is still living. And so the word spouse is used in many places in the Social Security laws. Or how about this? The tax-free status of employer-paid medical insurance for employees and their spouses. So you see, well, that depends on where you live, whether a spouse is considered a lawful status or not. And how about cafeteria plan eligibility? Yes, it's available to spouses. Or flexible spending arrangements and health spending accounts, expenses of spouses are treated the same as expenses of employees, but not non-spouses. How about sales of principal residences? The rules are very different. The benefits are different if a couple is married versus not married. And what about estate taxes? There's an unlimited marital deduction for spouses that same-sex couples are not going to realize in 37 states. And then, of course, whether or not you're eligible to file a joint tax return will depend on your marital status. So those are just a few of the more common. And I think that in practical terms for many churches, you're going to see, I think, the tax status of medical insurance paid by the employer is going to probably be, realistically, that's going to be probably one of the biggest impacts of this court ruling in those 13 states where same-sex marriage is recognized. And if you're in a church that is not opposed to same-sex marriage, and you have an employee who maybe is involved in a same-sex marriage, then that church is going to have probably to review the payroll withholding, have the employee submit a new W-4 form, and treat certain fringe benefits that pertain to spouses differently than in the 37 states where that's not the case. So those are some of the more important provisions under federal law of those 1,136 that are now in play.
Just an easy question. With the Defense of Marriage Act and with these provisions, if you're located in a state that does not recognize same-sex marriage, the federal benefits such as estate taxes, Social Security benefits, will those federal benefits not be available to people in the states that are located in one of those 37 states?
That's exactly right, and that's the disparity.
Okay.
You're treated favorably in some states, disfavorably in others, based on the status of that marriage. So that's why that is fueling litigation efforts right now to get this issue before the Supreme Court. And there's very little doubt, if you read some of the opinions, that a number of those justices were ready to make that decision on the spot, but they restrained themselves, and so we'll just have to see.
Okay, we've got a church that is doctrinally opposed to same-sex marriage, and it's located in one of the 37 states that do not recognize same-sex marriage legally. A same-sex couple asks the pastor to marry them. The pastor refuses to do so based on his religious belief. Does the Supreme Court decision striking down the Defense of Marriage Act expose the pastor to legal liability for failing to perform this marriage ceremony?
No, it doesn't. Number one, the court did not even address that issue in the DOMA decision. But number two, it only invalidated DOMA in those 13 states where same-sex marriages are legal, not in these 37 states where it's not.
Okay, let's say we have a church that is not doctrinally opposed to same-sex marriage, and it's located in one of the 13 states or the District of Columbia, and that recognizes same-sex marriage as legally valid. A church employee informs the pastor that she is planning on marrying a person of the same gender. How would the church be affected?
Well, this shows the disparity once again, because you can perform that marriage in this state because it's recognized as legal, and DOMA will not apply since same-sex marriages are legal in this state. So the court's ruling that it's unconstitutional would apply in those 13 states such as this one. Again, the biggest effect, Jerry, is going to be, practically speaking, in these kinds of churches, is going to be health care benefits paid by the employer for staff.
Okay, we have a church that is not doctrinally opposed to same-sex marriage in one of the 37, they're located in one of the 37 states now that do not recognize same-sex marriage. One of the employees informs the pastor she is planning on marrying another person of the same gender. How would this be affected by the court's decision?
Well, DOMA applies because you're in one of the 37 states that do not recognize same-sex marriage, so DOMA still persists in those states. And here we see that disparity again, which is likely going to lead to the Supreme Court weighing in on this issue.
So it's real important to pay attention to what state you're located in, and does your state have a constitutional ban on this? Because actually I know that right now there's several states that they're trying to push for that ban to be lifted. And if that changes in that state, the answers to your questions basically will change also based on if they are recognized or not.
Yes, that's right. That's exactly right. There are efforts underway, and these will continue to expand that list of 13 states where same-sex marriage is considered lawful. And I would suggest that we probably will see 3 or 4 or 5 states pretty quickly added to that list.